Welcome to Dorsey and Whitney's webinar on the Medley. I would like to introduce Nick Valistra, a partner in Dorsey's Finance and Restructuring Group. Nick, take it away.
Thank you. Good afternoon, everyone, and welcome to our September session of Dorsey's Bank Counsel Roundtable. Thank you very much for joining us again today. Before I introduce our speakers, I'd like to mention a few housekeeping items. If I could have the next slide, please. First, please remember to sign in on the attendance sheet we've provided and return it to attendance@dorsey.com. If you're looking for your attendance sheet or for today's presentation materials, they're available for download from Dorsey, from the Dorsey webinar reminder email sent to you earlier from events@dorsey.com. Second, we will not be having a Q&A session at the end of the panel presentation. So if you have questions for our speakers, you may contact them later using the contact information provided at the end of the presentation materials, or you may get in touch with your usual Dorsey relationship contact. Have the next slide, please. We've planned a 60-minute presentation, which we've entitled The Medley. A few different timely topics will be covered by our panel of 4 speakers. Those speakers are Baich, Erin, Bryan, Erik, Detlefsen, and Betsy Parker. By way of an introduction, Baich is of counsel in the firm's capital markets and corporate compliance practice group, and he practices out of the firm's New York office. Dan is also vice chair of the American Bar Association's Subcommittee on FINRA Corporate Finance, and is a member of the ABA Private Placement Task Force and the State Regulation of Securities Committee. Erin Bryan is a financial services attorney in the Finance and Restructuring Group at Dorsey and is co-chair of our Consumer Financial Services Group. Erin is also an American Bar Association Business Law Fellow and a member of the ABA's Banking Committee. Erin's located in Minneapolis. Erik Detlefsen is a partner in the firm's Finance and Restructuring Group and practices out of our Minneapolis office as well. Betsy Parker is a partner in the Finance and Restructuring Group and is co-chair of the firm's Lending Practice Group. She's also located in Minneapolis. There are more detailed bios of our speakers in the materials, as is their contact information. And with that introduction, I'll hand it over to Betsy Parker. Thank you.
Thanks, Nick. Good afternoon, everyone. If you've ever attended one of these bank roundtables before, you know that they often center on one topic for the full hour. But this month, we thought there were 3 topics worthy of mention. So my colleagues and I will be covering those with you today. The 3 topics are, first, the continuing saga of LIBOR replacement, which I'll be speaking about. The second will be hot topics in U.S. securities regulation of broker-dealers and investment advisors, which Dan Baich will be speaking about. And the third will be eMortgage developments, which Erik Detlefsen and Erin Bryan will be speaking about. Now, as Nick said, today's presentation is titled The Medley. We initially had hoped to do this presentation as a live stage presentation of Cats, but replacing the song lyrics with our own lyrics about LIBOR, eMortgages, and securities regulation. Unfortunately, COVID has prevented us from getting together to do that. So instead, this will be a more traditional presentation. You're welcome. But in the spirit of the medley, we have each identified a song choice that encapsulates, or at least references, our topic. So be listening for those. I think it will be an eclectic mix. All right, so we can get started with the LIBOR replacement update. Can I get the next slide, please? Thanks. First, a little background to bring us all up to the same place, as we have a wide variety of folks on the line here coming from a wide variety of backgrounds. LIBOR stands for the London Interbank Offered Rate, and it's a global floating benchmark interest rate. There are approximately $200 trillion in outstanding transactions that use the reference rate of US dollar LIBOR, and about 95% of those are derivatives. This presentation will be focused on LIBOR developments as they relate to the other 5%, which is the non-derivatives. Even though the bulk of LIBOR transactions are derivatives, 5% of $200 trillion is still a lot of money. And in fact, according to Bloomberg, there are approximately 10,000 US dollar LIBOR loans outstanding. That is a lot of loans. LIBOR is determined each day based on submissions of panel banks as to the rates at which they could theoretically borrow on the London interbank lending market. LIBOR has been a prevalent rate for over 30 years, but over time, the interbank borrowing has decreased to the point that there just isn't very much volume of interbank lending in that market anymore. So these panel banks are really having to estimate what it would be if they did borrow, and the result is a rate that is not based on actual transactions, but rather expert judgment. Over the last several years, this has been the source of a lack of confidence in the rate, and there have also been a number of rate manipulation scandals. In July of 2017, the UK Financial Conduct Authority announced that it would no longer compel LIBOR panel banks to submit their estimates after December 31st, 2021, at which point LIBOR will cease to exist. Next. So that's the 30,000-foot view of how we got to this place of replacing LIBOR and figuring out how to do it. So if LIBOR is out, what is in? The answer is generally going to be SOFR. The Alternative Reference Rates Committee, or ARC, is a committee convened by the New York Fed and the Federal Reserve Board to ensure a smooth transition away from LIBOR. The ARC has recommended SOFR as the replacement rate for LIBOR. So what is SOFR? SOFR stands for the Secured Overnight Financing Rate. It is an overnight, nearly risk-free rate and reflects a secured rate. So contrast that with LIBOR, which reflects an unsecured rate. It's fully transaction-based, reflecting a broad measure of overnight US Treasury repurchase financing transactions. Contrast that with LIBOR, which, as I noted earlier, is no longer transaction-based, but rather based on estimates and informed opinions of the panel banks. It has a robust underlying market of transactions, and therefore is not likely to go away anytime in the near future. Now, there are a number of different formulations of SOFR, some of which are currently theoretical only and don't yet exist in practice. And these different formulations can be calculated and compounded in ways that make it look functionally similar to or different from the different formulations of LIBOR. But even if it can be made to work somewhat like LIBOR functionally, there's always going to be this underwriting differential, which is due to the fact that SOFR is a secured rate and LIBOR unsecured. So there's always a gap between SOFR and LIBOR, even if we can calculate them similarly, with SOFR being a bit lower as a result of being the secured rate. Therefore, for existing transactions that are transitioning from LIBOR to SOFR, there's a spread adjustment that needs to be made to account for that gap in order to maintain the economics of the deal. One barrier to the formal transition to SOFR was that the spread adjustment was a big unknown. However, in July of this year, ISDA announced that Bloomberg would begin publishing the spread adjustment for use in derivatives. And earlier this year, the ARC announced that it would use ISDA's spread for loan products, although this still needs to be formalized with an official publication process. So while those spreads have not been formally published for loans, we pretty much know what they will be. So with this information, lenders and borrowers are a step closer to this transition because one variable is eliminated. Next. So how does this transition get done in our loan documents? As we transition away from LIBOR to SOFR, there are two alternative documentation approaches to be taken in transaction documents: the hardwired approach and the amendment approach. First, I'll talk about the hardwired approach. And it is at this point in my presentation that if it were not for copyright laws and lawyers, we would start playing my song selection across the airwaves, because the song I selected for the medley as a representation of LIBOR replacement is, you guessed it, the Metallica song titled Hardwired. It's off their fairly recent album titled Hardwired to Self-Destruct. Now, the whole purpose of the hardwired approach is to avoid self-destruction. So we'll stick with the title of the song rather than the album title, and we'll stick with Hardwired. And by the way, if you are inclined to add that song to your playlist, consider yourself forewarned. There's quite a bit of strong language, and it will not appeal to all tastes. It is, after all, Metallica, and the heavier side of Metallica at that. So, Hardwired is my LIBOR replacements contribution to the medley. For the hardwired approach, language is included in loan documents that provides that a mechanism for a specific replacement index, i.e. SOFR, to automatically transition upon a triggering event, or a benchmark transition event, as you would see in the sample document. This can include either a public statement by an appropriate administrator of LIBOR announcing index has ceased, or it could be a public statement that LIBOR is no longer reliable, likely as a result of not receiving submissions from a sufficient number of LIBOR panel banks. Now, the second approach is the amendment approach, which provides that upon a triggering event, the parties will amend the loan documents to implement a substitute rate. Up until now, the amendment approach has been the generally favored approach, and many on this line are probably quite familiar with it. The idea is that we could kick the can down the road while putting into place a structure by which the parties can agree later to whatever the general approach is that is prevailing at that time. But this summer, things have changed some. Next. So what's new? This June, the ARC issued new guidance recommending that new loans be documented without reference to LIBOR. The ARC also now recommends that all existing LIBOR loans that mature after December 31st, 2021 be amended to utilize the hardwired fallback approach. This is a change from its earlier guidance, recommending that either the amendment or hardwired approach be taken. In fact, the amendment approach does not even appear in the guidance this time, a clear signal that hardwired is preferred. Another major development is the fallback rate waterfall. After the occurrence of a transition event, the loan documents would provide a waterfall, setting out what the replacement benchmark would be. For example, it'll be A, and if A is not available, then it will be B, and if B is not available, then it would be C, and so on. Earlier guidance suggested that the fallback interest rate be, in order, first, term SOFR, which as I mentioned earlier does not yet exist, but would be the closest in form to term LIBOR rates, plus a spread adjustment. Second, to compounded SOFR in arrears plus adjustment. And third, to a borrower and lender selected rate that is the prevailing benchmark plus a spread adjustment. In June, the ARC changed this language by modifying the second tier of the waterfall to change the rate from compounded SOFR in arrears to daily simple SOFR. This change was for several reasons. First, one of the driving forces behind using compound SOFR in arrears was because that's what the derivatives market has already decided it's using. But it was discovered that there's actually very little difference between compound SOFR in arrears and daily simple SOFR when you lay the lines on top of each other on a graph. So these loans will still be hedgeable. Additionally, the daily simple SOFR rate is operationally much easier to implement and easier to use in transactions where there are intra-period payments, such as prepayments. It's operationally similar to what a daily LIBOR rate would look like, so the shift is less challenging operationally. Next. One thing I would also like to point out, the LSTA has issued a concept credit agreement that utilizes this daily simple SOFR. There are many changes in the concept credit agreement that differ from the one that they had put out earlier this year for SOFR compounding in arrears. And we could do a whole CLE that walks through the concepts of that the concept credit agreement and points out all of the changes. But one important point is the look back without observation shift. Daily simple SOFR is a daily in arrears rate, meaning that the interest rate for the full interest payment period won't be known until the end of that period. So how do you invoice a borrower for interest before you have reached the end of the period? Look back without observation shift. The interest rate looks back at the rate 5 days earlier than the start of the interest payment period, and that is the rate used in the calculation for day 1, and so on throughout the term of the interest payment period. This way, there are 5 days available at the end of the period for invoicing the interest payment and allowing the borrower to get their payment set up to be timely. Next. So what happened? Why these changes? The answer in both cases is progress. One of the things holding back the ability to switch over to LIBOR was an inability to determine rates. But 2020 has brought with it the publication of several of the different variants of SOFR rates and SOFR index. Also in 2020, Bloomberg began publishing the spread adjustment that would be added to SOFR to determine the LIBOR equivalent rate for derivatives, which, as I mentioned earlier, the ARC has signaled it will also use for spread for SOFR loans. With these two figures, lenders and borrowers can check off 2 of the boxes that were holding back the shift from LIBOR to SOFR. Third, with the passage of time, lenders and vendors have had the opportunity to put into place operational developments and improvements that make the shift operationally feasible. As part of this, the change in the ARC's recommendation for the hardwired fallback language from compound SOFR in arrears to daily simple SOFR is one that has made the operational aspects much easier. Daily SOFR is, from an operational standpoint, much like daily LIBOR. Many of the complications created by compounded SOFR in arrears simply do not exist with daily simple SOFR. Fourth, there's an increasing appetite for economic certainty for lenders and borrowers. There was a time where LIBOR was a safe place and SOFR was uncharted territory that was riddled with uncertainty. Well, things have changed, and now LIBOR is the one that brings with it economic uncertainty. It will go away, and we don't know the exact date on which that will happen. Lenders and borrowers alike need to be able to project out what interest revenues and expenses will look like, and the certainty that comes with shifting away from LIBOR sooner rather than later will allow them to do that. Making the change now, or agreeing to what the new rate will be at the end of LIBOR, also reduces the gamesmanship that can come with an amendment down the road. Ideally, the end of LIBOR would not be a disruption to the economics of a deal. But if 2 parties take the amendment approach and LIBOR ceases, a borrower in a strong financial position might be able to lever this change to get more favorable terms or other concessions from the bank, and vice versa. If the borrower is in a weak financial position, a lender might be able to lever this change to get more favorable terms or concessions from the borrower. Both of these outcomes, while benefiting one of those 2 parties on a micro level, is not good on a macro level because they insert an unnecessary level of uncertainty into both the financial markets and the ability of banks and borrowers alike to plan and project. Fifth, as we approach December 31st, 2021, which is now only a year and a quarter away, it's becoming clear that the more of these loans that are originated as SOFR loans or have hardwired fallbacks in place, the less painful that transition is going to be at the end of 2021. As I mentioned earlier, there are Bloomberg estimates that there are 10,000 USD LIBOR loans in place. That's a lot of loans, and that's a lot of amendments. Now, true, not all of these will mature after 2021, but the closer we get, the greater the likelihood that they will. If steps aren't taken now, what we will have is a massive backlog of loans waiting to be amended to replace the interest rate. And what that will mean is lots of unhappy borrowers who are paying more because they are sitting with loan documents that fell back under old language to prime or alternate base rate. This is needless and wholly avoidable, and part of the reason why it is expected that borrowers, to the extent they aren't already, will start pushing for the hardwired language to be inserted into their loan documents. Next. So now to move on to a few questions that are floating around there. If SOFR is the solution, and we're all being encouraged to use it, then why did the Fed use LIBOR for its Main Street lending program? Well, the Fed responded to potential participant input to keep it with a familiar rate. These participants are companies that were already struggling and dealing with all of the fallout from coronavirus. And they realized that switching at that point would add complications to a program for which time was of the essence. And these companies didn't have time to shift over to understanding a new interest rate and what that would mean for them. However, the Fed did recommend that all Main Street lending program loans include hardwired fallback language. Next question. It would be easier if we didn't have to deal with any of this. Is there a legislative solution to this problem? Maybe. But if there is, it will be narrowly tailored to apply only to loans with certain characteristics, i.e., no fallback language at all. The ARC developed proposed legislation for New York, as New York law is the prevailing governing law in loan documents and financial products. And the proposed legislation would require the use of the recommended benchmark replacement, SOFR, where the contract language is silent, or the fallback provisions prescribe the use of LIBOR. It would not override fallback language if fallback language exists in the agreement, but falls back to an ABR or prime rate. Even if this legislation is adopted, you don't want to be in the position of having to rely on it if that can be avoided. You will want to determine the rates for your loans on your own terms and well in advance. Next question. With all of the uncertainty that COVID-19 brought to 2020, everyone's had a wild year and hasn't been able to focus as well as we would like to on LIBOR. Won't the deadline be extended out past the end of 2021? The answer to that is no. There is no indication this will happen. Could it happen? Possibly. Will it happen? Not likely. While there might be a small shift in the ARC recommended milestones that lead up to that date of December 31st, 2021, and we have seen a little bit of that shift already, all signs point to the point that as far as the end date goes, it will still be December 31st, 2021 or thereabouts. Next question. What if term SOFR comes into existence after a hardwired loan has already transitioned to simple SOFR? Well, the LSTA Concept Credit Agreement recognizes that term SOFR is highly desirable and has included an option by which a loan could climb the waterfall, that is to go back from the second option of interest rate back up to the first, should it become available and sufficiently reliable that the parties decide to shift to term SOFR. Next question, so what's next? Well, the ARC is working on developing forward-looking term SOFR with the goal of publishing by June 30th, 2021. Now, as I mentioned, forward-looking term SOFR is highly desirable because it looks and feels the most like term LIBOR of any of the other SOFR variants, and for that reason would be very easy to operationalize. But because it's forward-looking, it requires a well-developed derivatives market and would have to surpass some other hurdles before it could be utilized even after it exists. Secondly, another thing that's in the pipeline is that the LSTA is developing a form of amendment documenting the hardwired approach. So all lenders will be eagerly anticipating receiving a copy of that amendment so that we might better utilize it in documenting loans as we move into 2021. So that is your LIBOR update for today. So I will now hand it over to Dan Baich to talk about hot topics in U.S. securities regulation of broker-dealers and investment advisors.
Thank you very much, Betsy. That was very informative. Thank you, everyone who has dialed in to hear us today. We really appreciate it. Now, when I was asked to do this presentation, and our topic was the medley, there was really only one song that popped into my head for this, and that was the 1987 classic, Welcome to the Jungle by Guns N' Roses, off Appetite for Destruction album. And the reason is that US securities regulation is certainly a jungle out there. You've got overlapping and competing regulatory agencies, such as the SEC, the CFTC, the NFA. You've got self-regulatory organizations such as FINRA. And in addition to that, you've got state securities authorities. And in many cases, the regulations are not harmonized. So it's all fun and games, to quote one of the song lyrics. Now, I wanted to talk to you about three germane topics here. Regulation best interest, FINRA's recent update of Rule 5110, and the SEC's custody. I'm going to start with regulation best interest. Last June, the SEC adopted regulation best interest under the 34 Act, and it imposes a principles-based standards and recommendations by broker-dealers to retail customers and recommendations by broker-dealers and their associated person. And they are required to act in the best interest of the retail customer at the time the recommendation is made without placing the financial or other interest of the broker-dealer ahead of the interests of the retail customer. And that has been a big problem for many years, in that broker-dealers are incentivized to sell certain securities or sell certain products. So the only way they can continue to have sales incentives and that type of thing is if the product is in the best interest of the retail customer, as well as in the best interest of the broker-dealer. Next slide, please. Now, in order to meet these best interest obligations, broker-dealers that are going to be providing these investment recommendations must adhere to 4 component obligations in the rule: the disclosure obligation, care obligation, conflict of interest obligation, and a compliance obligation. Reg BI tries to provide retail customers with a full and fair disclosure about the products and services offered by broker-dealers, including relevant conflicts of interest, to allow customers to make appropriate investment decisions that are pertinent to their investment goals and needs, while understanding the risks of those decisions. The idea is to provide customers with all relevant information, because broker-dealers would not provide those, disclose to a customer that, oh, by the way, we're having a sales incentive contest on this particular security. That information would never be relayed to a retail customer, even if it would be in their best interest to know that. Now, each broker-dealer and registered investment advisor must file a customer relationship summary form, the SEC, and provide a copy of each retail investor. 2 pages or less for a broker-dealer, 4 pages for a investment advisor. And it must summarize the business practices, registration status, relationships, costs, fees, etc. That broker-dealers and investment advisors are engaged in. Now, don't be fooled. The form may be 2 pages that you file with the SEC. The instructions to the form are 32 pages. Next slide, please. Now, I wanted to talk just briefly, and I could talk for hours about these things, but just briefly about the 4 component obligations of Reg BI. The disclosure obligation is to provide certain prescribed disclosures to the customer before or at the time of the securities recommendation about the recommendation itself and the relationship between the retail customer and the broker-dealer. So if it's a proprietary product that the broker-dealer is looking to sell to the retail customer, all assorted fees and everything needs to be disclosed to the retail customer. Now, the care obligation would be to exercise reasonable care, diligence, and skill in making the recommendation. Conflict of interest would be to establish and maintain policies and procedures reasonably designed to address the conflict of interest. Now, this one's very difficult to for broker-dealers to comply with, because they may not always know that there's a conflict of interest due to internal what's known as Chinese walls. So broker-dealers have had to reimagine their procedures so that they can provide disclosure to retail customers about conflicts of interest. And the final one is compliance. Final obligation is a compliance obligation to establish, maintain, and enforce written policies and procedures to comply with these 4 items, as well as the rest of Reg BI. Next slide, please. Now, the compliance date for Reg BI was June 30th, 2020, and it was not pushed back by COVID. So during the spring, in March, April, May, there was a big scramble to get broker-dealers in compliance with Reg BI while working remotely during COVID. And that was a bit of a challenge, and to the best of my knowledge, not everyone has made it into compliance yet. And here we are in September, but the SEC has said, do your best and keep getting yourselves into compliance, so that I don't believe that the SEC is, well, they haven't said this, but they're not taking enforcement actions if you're not in compliance due to COVID. Next slide, please. Now, as I was researching this, there was last month, the SEC released an FAQ about Reg BI that I thought was appropriate to this audience. If you are an associated person of a broker-dealer, but also a bank employee, what's known as a dual-handed bank employee, when you're acting on behalf of the bank, and if you use the term advisor or advisor in your title, does that trigger the Reg BI requirements? Commission says no. Reg best interest applies only in the context of a brokerage relationship with a brokerage customer, and specifically when a broker-dealer is making a recommendation. However, when the dual-headed bank broker-dealer employee is providing a recommendation to a retail customer, it would be a violation of this disclosure obligation to use the name or title advisor or advisor, unless the individual is also a supervised person of an investment advisor. And I include the link to that FAQ, and there's a ton of FAQs out there from the SEC, and they keep releasing them basically on a monthly basis. But I thought that this one in particular would appeal to this particular audience. Next slide, please. Now, revised FINRA Rule 5110. FINRA Rule 5110 is known as the Corporate Finance Rule, and it governs the terms, conditions, compensation, and other items that an underwriter may receive in a registered public offering. It's been revised after several years of give and take, and the most recent revisions went into effect last week, September 16th, 2020. And this would be relevant to any bank counsel that where the bank has an affiliated FINRA member that may participate in registered public offerings of securities. Next slide, please. March 2020, FINRA published the regulatory notice, which detailed all the changes to Rule 5110 and provides additional guidance on the implementation. Certain changes for public offerings were immediately effective with the publication, but again, the bulk of the amendments were implemented last week, September 16th, 2020. And I've already dealt with the FINRA Corporate Finance Department since those changes have been made, and it has certainly streamlined some of the FINRA filing process. Next slide, please. Now, the amendments primarily address the following. The filing requirements, which are changes as to the timing, modifications to the public offering system, and addition of new exemptions from filing and substantive requirements of the rule. Underwriting compensation, including adding definitions, significant changes to the venture capital exceptions, and helpfully, FINRA provided a lot of supplementary materials when they made this change to help guide firms as to what may or may not be underwriting compensation for purposes of this rule. Also, you've got lockup restrictions that include new exclusions for securities acquired in transactions that may meet the requirements of one of the venture capital exceptions. Next slide, please. FINRA also included certain clarifying changes about prohibited terms and arrangements, and they revised many of the defined terms to modernize them. Next slide, please. Now, the most practical and relevant change to Rule 5110 is that no longer will shelf takedowns be required to file with FINRA. You only file the base offering document. FINRA will issue a no objection letter, and you can go ahead and sell securities, which of course, and that's really the biggest change. And so no longer will there be a delay in a corporate finance deal. Now, that begs the question, well, how is FINRA going to determine if underwriting compensation is fair and reasonable in these takedowns if they're not filing them? That question I asked if they're not reviewing them as filings. Now, I was on a Zoom call yesterday with FINRA as part of the ABA annual meetings, and I asked that exact question. The response was that they had built a proprietary back-end system to search Edgar for shelf takedown filings, and will review those, and this system, apparently using AI, will search the underwriting agreements, the engagement letters, the shelf takedown documents for items that may be considered underwriting compensation, and where necessary, FINRA will go ahead and investigate, which sounds pretty futuristic, but that's what they told me. Now, what else does it do? What other changes are there to Rule 5110? It exempts certain employee plan securities, which is a good thing. It exempts underwriting compensation paid to non-U.S. broker-dealers for non-U.S. sales in a global offering. Now, I note that FINRA made a big point of saying, no, you cannot just load up your non-U.S. affiliate with compensation and say that it fits within this exception. So they're going to be looking at that. And FINRA has also clarified the venture capital exceptions from underwriting comp. Next slide, please. Now, additional highlights, the exceptions to lockup restrictions. It simplified the current provisions relating to payments made by an issuer to waive or terminate a ROFR. And they excluded things from the prohibited terms and arrangements that may, that really codified what existing positions were, that advances against expenses are not comp, and payment of consulting fees or advisory fees would not be comp if they're paid to the issuer. Next, or paid by the issuer. It also revises certain defined terms that reorganizes and modifies 5110. And the changes to the public offering system make the filing process itself much easier to navigate. And it added two offerings that are exempt from 5110, and that's generally private offerings. Next slide, please. Finally, my final topic is that recently the SEC has increased enforcement of the investment advisor custody. The investment advisor custody rule is a rule that comes into play far more often than you would think, because an investment advisor could be deemed to have custody of customer funds in many occasions, such as where you would not think there was custody involved, such as if they can move funds between customer accounts, whereas if the investment advisor has check writing authority off those funds, they may be deemed to have custody of those funds. And the SEC in 2017 came out with a no action letter and new policy position paper about the custody rule. So in the last 18 months, the SEC's enforcement division has been very active investigating and enforcing the rule, custody rule, because they put such effort into coming up with that 2017 guidance, that now their enforcement division is really bringing custody issues to the forefront. So that's I guess a bit of a warning for me if you have an affiliated investment advisor, to make sure that from a custody perspective, all your I's are dotted and T's crossed, because the SEC is coming. And then they really highlighted two key areas under the custody rule that can result in liability. Next slide, please. First, in addition to maintaining client funds and securities with a qualified custodian, advisors with custody must obtain either A, a surprise examination, which is expensive. Generally, it's estimated that it costs $100,000 to $125,000 a year for that surprise examination, or an annual audit. Most registered private fund advisors rely upon the annual audit approach. Next slide, please. And sometimes you could fail to meet the deadlines on it, certainly in a COVID world. And the SEC has some flexibility on that, but the flexibility certainly has limitations. Next slide, please. Secondly, the custody rule requires the accounting firm performing the exam or the audit to meet auditor independence standards set forth in Regulation SK. Provision of non-audit services by the auditor can jeopardize the auditor's independence. And registered advisors with custody of client assets should be careful when maintaining such assets with qualified custodians and engaging auditors in order to avoid violating the custody.
Thank you so much, Dan. That was very informative. This is Erin, Bryan, and I will be speaking with Erik Detlefsen about eMortgage developments. Electronic mortgages have been discussed for many years, but there have been delays to implementation. Before we get to the substance of what's happening now, I think it would be helpful to level set about how we got here and briefly go over the history. So back in 1999, the Uniform Law Commission introduced UETA, the Uniform Electronic Transactions Act. This is a legal framework for electronic alternatives to wet ink signatures. This was followed in 2000 by a federal law, the Electronic Signatures in Global and National Commerce Act, commonly known as e-Sign. And under e-Sign at a federal level, there is now legal recognition for electronic signatures in most types of transactions. By 2019, the technological infrastructure for electronic notes in mortgage transactions was in place, but there were still a few issues to be worked out. Some warehouse lenders began funding e-notes at that time, and Fannie Mae and Freddie Mac began purchasing and securitizing e-notes, while numerous private investors began purchasing e-notes. As of this year, UETA has now been adopted in 47 states, and Ginnie Mae is also securitizing e-notes now. There have also been some unexpected developments this year that we're all familiar with. For one thing, there have been historically low interest rates. This has led to a huge demand for refinancing of existing residential mortgages. But at the same time, there has been a global pandemic, and this has caused disruption and also led to innovation. It's caused a need for technological adaptations due to the need for social distancing and remote operations. In addition, people working from home has led a lot of people to want to upgrade their home or move to a different area, leading to an uptick in home purchases. State executive orders relating to COVID temporarily expanded the availability of remote online notarization. And as of the date of this presentation, there are currently 48 states in the District of Columbia that allow remote online notarization. So some of the technology has been pushed forward a little bit more quickly by the pandemic. It will be interesting to see how much of this stays in place afterward once people in the industry become familiar with these processes and comfortable with using them. All right, so electronic mortgages. With a paper mortgage, a closing requires basically three things: a mortgage, which has to be signed, notarized, and recorded, a note, which has to be signed, and then there's a lot of disclosures and other documents, most of which need to be initialed or signed or both. So we can cue my song here, Stevie Wonder singing "Signed, Sealed, Delivered." And currently at a state level, every state except Vermont is allowing electronic recording. However, variations do exist at a county level. All right, so e-sign and UITA for electronic signatures. There has to be an intent to sign. There has to be consent to do business electronically. There needs to be a capability to associate the signature with the record, and then there are record retention requirements. In terms of security interests and perfection, UITA and e-sign do not provide a mechanism for perfection of security interests. And as of our last search, there was no case law on whether the typical mortgage note really is a negotiable instrument. Some academics have raised questions about whether the standard mortgage note is in fact a negotiable instrument. We've taken the position that a financing statement is likely needed to perfect. A note now on the priority of security interest in e-notes. So if an e-note would be a negotiable instrument if it were in paper form, then the electronic vault concept under e-sign and UITA give the party that has control over that e-note the rights of a holder in due course, including priority under UCC section 9331. Priority for an e-note that's a negotiable instrument can be obtained via an electronic registry if all legal requirements are satisfied. Priority, however, for an e-note that is not a negotiable instrument is governed by the first to file rule. So this distinction becomes important. Intercreditor agreements may be needed where there are prior overbroad filings. All right, I mentioned that the technological infrastructure is now in place. There are several vendors providing competing eVault products, and these are the tracking of e-notes. And all of those systems are attempting to satisfy the following legal requirements. First, there must be what's called a transferable record. This means an electronic note that expressly provides that it is a transferable record. Second, that record is created, stored, and assigned in such a manner that satisfies the following criteria. So there must be a single authoritative copy of the transferable record. It must be unique, identifiable, and unalterable. The authoritative copy must identify the person asserting control as the person to which the transferable record was issued, or if the authoritative copy indicates that the transferable record has been transferred, the person to which the transferable record was most recently transferred. And lastly, the authoritative copy is communicated to and maintained by the person asserting control or its designated custodian. All of this is incredibly important to warehouse providers, which serve a crucial role in the residential mortgage industry. Warehouse providers are typically banks that provide short-term liquidity to independent mortgage bank and non-bank originators of residential mortgage loans. They extend lines of credit to the IMBs or non-banks to fund the origination of new loans from the initial closing until the eventual sale of the loans in the secondary market. Without this, smaller originators would likely not have the liquidity to close new loans. The warehouse lines of credit are collateralized by the underlying loans. Possession of the note has been crucial. Although there are exceptions, warehouse agreements typically take the form of repurchase agreements, purchase and sale agreements, participation agreements, or credit agreements and security agreements. MERS has developed an e-registry with mechanics that address secured party concerns. So first of all, the warehouse relationship must be established on the MERS system. Second, the warehouse provider's interest must be noted on that e-registry. The registry has two possible designations, controller and secured party. Transferring a note to the investor can be initiated by the controller, but still would require the secured party's consent. Transfer of a note can also be initiated by the secured party, for example, in an enforcement case. The Fannie Mae delivery agreement presumes the warehouse provider is the controller. In terms of the release of security interests in loans, Fannie, Freddie, and Ginnie will dictate the terms for release in the loans that they buy. The Fannie Mae eNote Control Transfer and Custodial Agreement provides that control on the e-registry is transferred to Fannie Mae when the eNote is delivered. Fannie acts as custodian for the warehouse provider until it pays for the note, and wire instructions are provided through existing Fannie Mae delivery system. As noted earlier, warehouse providers can't rely on UCC 9313 for preservation or perfection. Without 9313 rights, warehouse providers must have a binding contractual obligation from the investor to deliver proceeds. And the release of a security interest will be left to agreements between the secured party and investor. This also means that master bailey arrangements will be required for sales of loans to non-agency investors. And that raises some questions. For example, will investors require transfer of control and location of the eNote before they fund? Probably. And also, we note that master bailey agreements must protect warehouse providers' liens until the required funds are actually received. And now I will turn it over to my colleague, Erik Detlefsen, to talk about some specific considerations for documentation.
Yeah, so if you think about kind of compared to the wet ink asset paradigm, which has its own set of music and songs and all that, I'm going to instead teach you the electric mortgage slide. Some of the practical and technical aspects of eNotes. There's actually a lot of lyrics to the electric slide that work. You can't hold it, it's electric, but you know it's there so long as it's the authoritative copy. It goes on. It's a really, really long song, as you know, from any wedding you've been to before COVID. But so I guess with time allotted, really in terms of the documentation and practical considerations, is kind of just a corollary of what the legal background that Erin presented, right? So thinking about what should go into the docs, or if you're the drafter, or if you're supporting a business line, where should legal be focusing in a warehouse transaction? Kind of keeping it at a practical high-level takeaway here. I think the first thing in the MRA, the master repurchase agreement, or your warehousing loan agreement, when drafting definitions or your collateral or transaction description, when defining what an eNote is, I've described this as the transferable record trap, but and Erin mentioned this, right? If an eNote is not a negotiable instrument, so the underlying document, the note itself is not a negotiable instrument, then the asset that's being warehoused or purchased is not a transferable record. Okay, so if in your granting language or the transfer language, you say that the buyer is buying all eNotes that are transferable records, or your definition of eNotes is limited to things that are transferable records, I guess our view is that you're being too narrow in creating transaction risk for the client, right? So I give an example definition of eNote there without a limitation to transferable record. Now, if you flip it and you are talking about the covenants and conditions in your documents, you do want to require, of course, that it be a transferable record, as that's a condition to control and to obtaining control through the e-registry and e-vault mechanic. One other kind of, again, practical consideration is if you compare to a paper note warehouse deal, and think about filing a UCC, or think about some intercreditor dynamics, typically I'd say most warehouse lenders do file a financing statement describing the purchase asset as collateral sort of in the alternative. You really don't need that though, right, to perfect, because you get physical possession of the paper note. It may be at your own bank or through a custodian or bailee arrangement. But here, right, if it's not a transferable record, again, then you don't have possession through control, or perfection through control, and you need to perfect by filing. The other kind of practical consequence of that is when in a normal paper asset warehouse deal, if you see an overbroad filing, it's not as much of a concern because you get a first priority interest through possession, through control, under a bailee arrangement or a custodial arrangement, or by physically holding the note. Well, here you're kind of in a first to file situation, right? And so if there's a pre-existing overbroad filing, you're going to need to get an intercreditor agreement with that other warehouse lender or that other secured creditor in order to ensure, that you have first position. Erin, jump to the next slide. Thinking about so it's not necessary to have a custodial agreement. I think from a kind of a vendor management, because this is unique and new, especially smaller warehouse lenders, I think are finding a party that has this infrastructure, the eVault software, and the relationship with MERS already set up, that a custodial arrangement is a path that's being taken, I guess, by especially smaller warehouse lenders. I see that the important thing in that document then is to correctly or to ensure that your custodian has correctly identified the various roles, right? So the custodian needs to be the delegatee for transfer. The buyer is the controller, and the MERS e-registry is the location, or rather the custodian in the e-registry is the location for the notes. And then your custodial agreement is going to have some sort of mechanism for transfer. Erin alluded to this, so at the end of the warehouse period or when it's sold to an ultimate investor. Another point that we're seeing, so when dealing with the agencies, so Fannie, Freddie, Ginnie now as of late, you're going to have a prescribed form of release for when the transfer takes place at the end of the warehouse period. Private investors, we are hearing and seeing that process hasn't yet kind of shaken out in the market as to what does it look like to transfer to a private investor in an eVault. And in a normal paper deal, we use something like a bailee letter or escrow instructions. But in this space, it's going to be some sort of custom agreement that specifies, what do you do if there must be, the investor must be willing to pay before the transfer, and then agree, similar as in a bailee letter, that there can be no right of set off if something less than the minimum price is paid, that there must be a mechanism to transfer or redesignate the custodian, if that was held under a custody arrangement, as the delegatee, and to redesignate the buyer as the controller in the eVault and in the e-registry. So that mechanic is going to be a little bit nuanced and different. Another, I think, kind of touch point. So in addition to that transferable record trap, the UCC and intercreditor dynamic, and then also this concept of what do you do when transferring to a private party? I think those are some kind of yet to be sussed out pieces or questionable issues in the law, beyond just kind of translating everything that Erin articulated into your document with a suite of reps and conditions and the related definitions. So I think that's probably good enough on eNotes. And of course, if there's questions, shoot us a note. But Betsy, if you want to kind of round it out on the Medley piece and perhaps play us out to Metallica, that would be great.
I won't be playing us out, but I will say, that's the conclusion of our program. Please do be sure that you remember to turn in your completed sign-in sheet so we can make sure your CLE credit gets recorded. Please send us questions. Our contact information is included in the slides if you have any questions. And hopefully there was something in there for everyone to take away. At worst, you ended up with an hour of CLE credit and a few songs to add to your playlist. So thanks everyone for joining us, and we will see you at next month's Bank Counsel Roundtable. Have a good weekend.